Hello, and welcome to the Pro Business Regulation webinar series this afternoon. I am Amir Rizal Mohammed, coming to you live, as always, from Kuala Lumpur. Your Pro Business Regulation webinar series starts right now. I am delighted to welcome you all onto the Pro Business Regulation webinar series, brought to you by the Malaysia Productivity Corporation, MPC, a statutory agency under the Ministry of International Trade and Industry. Thank you for sparing your time to join us today. So much ground to cover on this edition of Pro Business Regulation webinar series. We bring experts to share information regarding regulatory practices to help policymakers, regulators, businesses, academia, researchers, and interested parties to enhance knowledge on how to improve the quality of regulation. Thanks to MPC as the organizer of today's webinar for helping us all stay productive in the midst of pandemic. You may also learn more about past and incoming webinars hosted by MPC through the social media. Don't forget to like and follow MPC's Facebook page, Twitter, and Instagram, or visit MPC's official website, www.mpc.gov.my. We are happy to learn that many have registered their interest in today's webinar, and we are still seeing a number of participants coming into the webinar as we progress. Those who just got their way into the webinar, you are now watching Lessons from COVID-19, Time to Legislate. Before I kickstart today's session, I am also happy to share that the Legal Affairs Division, BHEUU, at the Prime Minister's Department is coordinating the drafting of a temporary measures bill to mitigate the impact of the COVID-19 and the Movement Control Order. This bill will include provisions that modify existing laws for a prescribed period that impede the collective effort to revive the economy and to assist those affected by the pandemic. The division welcomes comments and suggestions from the public that could assist them in the drafting of the proposed bill. You can do so by visiting the Unified Public Consultation UPC at upc.mpc.gov.my. You can also find the links posted in the chat tab in the taskbar at the right corner, or visit the MPC social media outlets. MPC has also established a virtual advisory clinic, VAC, for regulatory impact analysis, RIA, for helping the public and private sectors draft a new or review a regulation. If you're just unsure how to conduct a good public consultation or struggling to produce quality regulation, feel free to make acquaintance with the VAC specialists. They are pleased to engage with you in a 1-hour clinic session on the regulations. You can learn more about the virtual advisory clinic by visiting mpc.gov.my. Following the COVID-19 pandemic engulfing worldwide, Malaysia is without exception. Private sectors have been severely affected since the Movement Control Order announced by the Prime Minister of Malaysia. Businesses are forced to suspend their operations to contain the coronavirus. The impacts of COVID-19 are real. We are all in the same boat, as we often hear from others. The question is either to save the crews or to save the boat. Some businesses are struggling to continue fulfilling contracts, paying rentals, wages, and other obligations to stay afloat. But they are constantly bleeding in thousands or millions of ringgits. For less fortunate ones, they are preparing for a voluntary winding up, of those facing bankruptcy. We are seeing more and more casualties due to this pandemic. Let's not forget the employees who have lost their jobs and incomes too. The government has announced several stimulus packages to cushion the impact of COVID-19. As assured by the Prime Minister, no one left behind. As the end of pandemic is hard to predict, offering stimulus packages continuously may only be effective in the short term, while the private sector calls for the government to review laws that restrict the businesses. Singapore, for example, has embarked on promulgating a new legislation in light of COVID-19. Questions remain. What problem to address? What should be covered in the legislation? What should we learn from other countries in this regulatory effort? Most importantly, what Malaysia can do to reduce the impact of COVID-19 and future-proof this country from any crisis to stay on top of its game. Joining us today, two guest speakers, Mr. David Lee and Ms. Lee Yi Fern from Zul Rafique Partners, who will enlighten us on the struggle faced by the private sector and share their ideas on regulatory solutions to these problems. Welcome, David and Yi Fern, to the panel. How are you today?
I'm good, thank you.
Thank you
for having us.
That's good. As today's webinar is a guided presentation, we welcome questions and opinions through the GoToWebinar question. If you have any questions or would like to share your concern, you may do so by dropping them in the question tab, which can be found in the taskbar at the right corner. I hope during the course of presentation, we will have questions coming in. We will keep 10 to 11 minutes at the end of the presentation for your questions. I appreciate if you would keep your questions brief and concise. Let me begin with Mr. David Lee. So David is a corporate partner at Zul Rafique Partners. He focuses primarily on capital market practice, merger and acquisition. He has extensive experience in providing advisory to the public listed companies on compliance matters. He also sits on the Bar Council's Corporate and Commercial Law Committee and a member of Inter-Pacific Bar Association. Moving to Ms. Lee Yi Fern. Yi Fern is a legal associate at the same place as David is attached to. She advises on projects, oil and gas, construction and infrastructure laws. Her notable client includes Petronas and its subsidiaries. She also advises on concession agreements with the government, subcontract agreements, and legal documentations. All right, ladies and gentlemen, please welcome our speakers. David, the floor is yours.
Many thanks for your kind introduction, Rizal. Thank you so much. A very good afternoon, everyone. And thank you so much for taking time off your busy schedule and for some from the comfort of your home to tune into this webinar. On behalf of everyone at Zul Rafique Partners, I extend our deep appreciation to MPC for inviting and extending to us this opportunity to air and share our legal thoughts on its platform. As introduced by Rizal, I'm David Lee and I'm a partner in the corporate department. Together with my colleague, Ms. Lee Fern, we will share with you this afternoon our thoughts on the law that our legislature may consider adopting as we combat this COVID-19 pandemic as a nation. In terms of the flow of our presentation, we will first make an introductory remarks on the COVID-19 pandemic, although given all the narration available online, COVID-19 and its impact really doesn't need any introduction or elaboration. We will then touch subsequently on the laws introduced by other countries, such as Singapore, Australia, and the United Kingdom. We will then present our suggestion on the shape and substance our law may take. At the end, if there's any questions, we will take them. The COVID-19 pandemic declared by WHO in early 2020 is the latest crisis after three crises in the past 3 decades that had more or less culminated adverse effect and impact regionally and globally. In the late 1990s, Asians experienced a financial crisis that witnessed World Bank and IMF stepping up to assist countries like Indonesia and South Korea. Then in early 2000, we had the SARS outbreak, which affected primarily Hong Kong and Singapore. In 2008, America suffered its subprime mortgage crisis, which also affected most economies globally. Now, today, we have COVID-19 pandemic, which abundance of literature have commonly described it as simply unprecedented. As at 2nd of June 2020, WHO reported 6.1 million confirmed cases and close to 380,000 deaths. Almost every country on this planet has been infected by this deadly and potent virus. Given the global impact of this pandemic, the World Bank in its June report found COVID-19 to have struck a devastating blow to an already fragile economy of the world. It also projected a not so rosy short-term future globally. In April, Bank Negara Malaysia (BNM) projected Malaysia's growth measured by GDP to be between -2% to 0.5% in 2020, due to the challenging global outlook caused by a combination of factors, with this pandemic being the main cause. With such gloomy outlook, many countries took immediate steps to legislate and implement legal measures to address and cushion the potential economic downturn. Singapore enacted the COVID-19 Temporary Measures Act 2020 in April. So did countries like Spain, Chile, Australia, and the United Kingdom, just to name a few. Next slide, please. The new law in Singapore essentially provided temporary relief for parties who are unable to perform their contracts which are specified in the Act. It also provided temporary relief financially to distressed individuals and firms and businesses in Singapore. It also provided temporary measures for conduct of meetings and court proceedings in Singaporean courts. For the United Kingdom, they have passed the Coronavirus Act 2020, which in a nutshell provided protection from eviction of residential tenancies as well as business tenancies. And they also provided statutory sick pay compensation for emergency volunteers. They provided indemnity for health service activities and also expanded life links to certain court proceedings. More interestingly, it also empowered certain authorities to require a person to provide information to establish whether a food chain is being disrupted or at the risk of disruption. So it basically had measures to ensure that the food supply is not halted or affected adversely. The United Kingdom Act, however, has a time frame of 2 years with a sunset clause of time limit of 2 years, and it will be subject to parliamentary review up to 6 months. In Australia, meanwhile, the government has passed the Coronavirus Economic Response Package Omnibus Act 2020 that provide economic response in the form of temporary relief, again, for financially distressed individuals. And they also provided relief for directors from the duty to prevent insolvent trading. More interestingly, under the guarantee of lending to small and medium enterprises, Coronavirus Economic Response Package Act 2020, the minister responsible is empowered to provide government guarantee to qualified loans made to SME entities by banks and financial institutions. With all this enactment, it is unsurprising that there were early calls by stakeholders in Malaysia for similar enactments in Malaysia. Our honourable minister in the Prime Minister's Department for Parliament and Law, Yang Berbahagia Datuk Taqiyuddin Hassan, announced last month that new bills on COVID-19 will be tabled in Parliament this July. So for purposes of today's presentation, we weighed the approach that our legislators can consider taking. Should the new law adopt similar provisions like the ones taken in Singapore, UK, or Australia, but localized perhaps to suit the Malaysian landscape? Should there be a single act called COVID-19 Temporary Measures Act that will provide statutory financial relief and aid, and that will interpret or change existing statutes during the COVID-19 pandemic, like the Singapore position? We took a step further. We considered whether, do we really want to just have a law for COVID-19 only? A law that will have a sunset provision like the UK law. What happens when the COVID-19 is over? That law will not be applicable. What about future crises? After lessons from COVID-19, I think we should have a law that will be applicable to any crisis that the nation faces. It can be a standalone, a one-size-fits-all type of law that will be applicable if and when a crisis like a COVID-19 is declared by the Malaysian government or the National Security Council. Of course, this law will be subject to our federal constitution, rendering the declaration of emergency to be enshrined intactly in our federal constitution. We were thinking that by having this law, Malaysia will be well prepared in case, touch wood, another crisis having similar or worse impact on our lives and economy occurs in the future. This type of law will of course required to be updated and amended from time to time by Parliament in order to keep up with these times. So what type of, what provisions should this law contain? Whether is it a COVID Act by itself or what we call a Crisis Interim Measurement Act, CIMA for short. My colleague Fern will now take you through the suggested provisions that our legislators may consider adopting in either of these laws. Over to you, Fern.
Yes, thank you, Mr. David. Can everybody hear me? Yeah. So, as per what Mr. David has said, that Malaysia can have two approaches in its legislative approach. One being the COVID-19 Act, the other one being a Crisis Interim Measures Act. The government can actually, we are thinking that the government can actually, proceed to, enact a COVID-19 Act. So in the event that once it's enacted, it's implemented, whatever implementations, lessons learned from the implementation, you can actually bring it forward to become a Crisis Interim Measures Act. Now, as far as COVID-19 Act is concerned, or the bill is concerned, we were made to understand that MITI had a consultation with stakeholders, relevant stakeholders yesterday. And although we do not know what transpired in the consultation, what was the outcome of the consultation, what we put in the following slides is actually what we anticipate from the public feedback. So on to COVID-19 Act, we put it as an expected fundamentals of COVID-19 Act. It should address the COVID-19 pandemic impinging on the well-being of Malaysia and its citizens, and to provide temporary relief to individuals, businesses, firms in Malaysia during the COVID-19 pandemic period. This should be applicable to all states in Malaysia. Next slide, please. So the COVID-19 bill or act should contain a commencement date and a sunset clause, unless renewed by the Parliament in the event of a spike of COVID-19 case. Now, the commencement date is a date that the government has to determine on itself prior consultation with all the stakeholders on what is the best date that all stakeholders, all relevant industries, all businesses and individuals feel that that date is when the impact of COVID-19 was first felt. And the sunset clause is also something, a sunset date will be a clause that the government would have to determine itself as well. So the COVID-19 bill should also contain provisions where it will apply and even override certain relevant written laws, except for federal constitutions, during the COVID-19 pandemic period. This act should not be construed as a declaration of emergency under the Article 150 of the Federal Constitution. Now, moving on to CIMA, the notion of CIMA is that it is an active response plan, much like the Prevention and Control of Infectious Diseases Act 1988, which we are fortunate to have, where there is a legislation intact, and what the government or the ministry should do when a crisis has been declared is that they issue a specific orders under the Act, but the Act itself would have a proposed fundamentals or principles. So in a nutshell, it is like a framework legislation, or for businesses, it will be like a umbrella agreement or framework agreement for that matter of fact. So what should contain in what is proposed to be contained in the CIMA proposed fundamentals is that it addresses any pandemics, global crisis, national crisis, or unprecedented crisis, what we call specified events for purposes of this presentation slide, which impinges on the well-being of Malaysia and its citizens. And it also provides temporary relief to individuals, businesses, and firms in Malaysia during control period. So what is a control period for purposes of this slide is that the period of time declared by the Prime Minister after consultation with National the National Security Council as control period. And this act will be applicable to all states in Malaysia, and it allows for specific orders to be issued under the act to cater to different crises for the time being and different measures that needs to be required. So on to the scope, so these provisions in CIMA shall apply and override also certain relevant written laws during the control period except the federal consti, and it should not be construed as a declaration of emergency under the Article 150 of the Federal Consti. Now, next slide, please. Yes. So, scope of legislation, what we intend here is that it should not be limited to COVID-19 Act. It can be applied to CIMA as well. But the only difference is that the drafting of CIMA would be a very different way of drafting. Though the idea, the principle is there, the drafting of it will be different. So, the first scope of legislation would be the statutory extension of contractual timeframes. Now, usually for contracts, the common definition of days is calendar days, and the common definition of business days is a day which is pegged to the banks being open or not. Now, if the audience could remember or recall that during the MCO period, the banking and finance services industry were actually classified as essential services. So, in other words, they are actually open. So, unless a contract has a watertight force majeure clause, or unless it has a watertight as well extension of time clause, chances are that the computation of time in normal contracts would have been running during the MCO period. Now, if a parties fail to comply with contractual timeframes, it may raise arguments on breach of contracts, or it also raise an argument on waiver of rights. So, a statutory extension of contractual timeframes is actually should be included in all this legislation, in our legislation for COVID-19 and or the CIMA. So, for example, I would take completion of projects because that's my forte. So, if the government is intending to enact a CIMA, or when they're enacting the COVID-19 Act as well, they should also be wary that statutory extension of contractual time, the wording must be drafted properly as well. For completion of there must be a what you call a causal requirement where the COVID-19 pandemic and the MCO has impacted the parties to fulfill their obligations under the contract. So there must be a causal requirement. The other options the other thing that they could add inside the drafting of the act itself is also to include mitigation requirement. In other words, the party who is relying on the extension of time should show that they have done mitigatory steps, reasonable mitigation steps, to avail itself to this relief under the act. So moving on, the other scope that the legislation should consider would be the statutory extension of statutory timeframes. Now, in any statutes where timeframes are prescribed, is a strict compliance, and failure to comply often attracts penalty, fines, or charges. So the following statutes these are the statutes that we find are examples for the statutory extension of statutory timeframes to be applicable. AGM, circulation of financial statements or lodgement of financial statements with CCM, even for tax-related matters, fiscal legislations, and so on. So the third scope would be force majeure related matters. Now, in contracts, most likely we will see cases where a party has a very strong, very watertight force majeure clause. There's no problem already on that. So then you have another scenario where the parties have a force majeure clause, but it's not watertight. So they may lose out on it doesn't contain pandemic, it doesn't contain epidemic, it doesn't contain beyond parties' reasonable control, etc. Or you can be a situation where the parties do not even have a force majeure clause. So what the legislation could do is that it could have a statutory implied term on force majeure provisions into contract which do not have such clauses. But I would caveat it to a certain extent where it should depend on the subject matter of the contract, because you know MCO has been going on for the past since March, and COVID-19 has been around already. Parties may have moved on with life, and they may have settled resolved their disputes and things like that. So if we are going to have a statutory implied force majeure provisions to every contract, we may to some certain extent open another lacunas or another loopholes and another disputes out of nowhere. So we want to avoid all these things. So perhaps the legislation could also address that, for things that have already been resolved by parties, these are not applicable. So another force majeure, sorry, back again. I haven't finished. Yeah, okay. So another one would be a statutory provisions that effectively and legally extend force majeure, or the interpretation of force majeure into existing clauses to include pandemics or specified events. So moving on. Yes, on the property front, the legislation can prescribe a suspension or deferment of rental payment for business or commercial properties or even residential properties, and also prescribe a graduated threshold rental reduction. And for condos, it can suspend, defer, or reduce payment of maintenance charges or contribution to sinking fund. But I would also say that it should any condo the MC or this one will have to consult with the parcel owners, because this would tie back to the service levels of the condos, the maintenance of the condos. The other one would be a waiver of late payment interest as well for the legislation to consider. Moving on the taxation front, the legislation could include that assessment of stamp duty and real property gain tax to be based on the lower between purchase consideration and the market value of property during the COVID-19 period or during the control period. There can be a suspension of payment of sales and service tax, or there can be a reduction of rate of tax. Now, the reduction of rate of tax should depend on the economic situation of the country, because tax collections is the government's revenue. So it's something that MOF or the other ministries should actually assess the situation first before they actually include it inside this legislation. Moving on the dispute resolution matters, it could also include suspension of limitation period under Limitation Act, Civil Law Act, and other statutory enactments. Now, as few weeks ago, as if the audience could recall, there was a press report that a supervisor who was sacked was not able to file his complaint with the Industrial Relations Department because of the fact that the office was closed within MCO. So that perhaps should also be looked into as well. Moving on. So on court proceedings as well, the legislation could also include automatic application on statutory prescribed methods of obtaining deferments or postponements, or a substituted service for writ of originating summons without an order from the court, and also allow the Chief Justice of the Federal Court and the Rules Committee to immediate promulgate rules of court for purposes of streamlining the mechanism of justice before and during the control period, and also prescribe for virtual appeals and other types of appeals, or other types of hearings. So next slide, please. Yes, so on the dispute resolution front as well, the legislation should also consider compulsory adoption of mediation as an alternative dispute resolution that arose for all disputes that arose during the crisis. And it could also consider setting up a panel of assessors from various professional bodies. Now, I would like to highlight that if these methods are included in the COVID-19 Act or the CIMA, the people who are the mediators or the assessors should come from various industries as well, because for example, and they have the relevant expertise as well. So for example, if the panel of assessors or mediators, they are lawyers, for example, even lawyers between me and David, right, we have our own expertise. So I may be I am expert in I focus my expertise on projects and construction, so I'm be more well versed with the construction and projects industries, whereas David is from a corporate finance side, so he's more versed on the corporate finance area as well. So it's something that the legislation should also consider. So moving forward, employment matters. The statute or the legislation, COVID-19 bill or the CIMA could also include the applicability of statutory terms to specify employment contracts or arrangements, such as paid leave granted to employees, no termination of employment or retrenchment, and to address the issues on cost of medical treatment for infected workers as well. And moving forward, on the financial front, the legislation could consider increasing the limit for individuals and companies to be applicable during control period, and also a declaration of moratorium or suspension of payment of loans, hire purchase, credit cards, and suspension of interest. And then on the moratorium front, on the financial front as well, there will be a moratorium on winding up proceedings and bankruptcy proceedings, something that the legislation could consider, and also on relaxation of director statutory duties for insolvency trading during the control period. And moving on. Next slide, please. Yes. So on the Personal Data Protection Act, now if the audience, I don't know whether anybody noticed it, especially during the CMCO period when restaurants, retailers, shopping malls are required to comply with the SOPs. We are supposed to have put our data in and things like that. So something the legislation could consider would be the data collected for purposes of compliance of SOP and how the data are going to be addressed, how it's going to be collected, how to be destroyed after the COVID-19 period. And for purposes of CIMA, moving forward, the relevant ministries can develop apps and software for purpose of collecting, storing, and destroying data during and after the control period. Next slide, please. Yes, so I think this will be the last one. Oh no, this is not the last one. Okay, so the legislation could also consider a statutory modification to existing laws and contracts to allow, in order to effectively and legally allow the use of alternative mode of service, submission of documents, execution of documents, conduct meetings, and conduct business. The reason why I included this is because for purposes of HDA, Schedule G and Schedule H, if you notice the notice clause inside the Schedule G and Schedule H, or for example, most contracts, if it's updated, most contract right now will consider that the notice clause will include things like registered posts, by hand, but during MCO period, we are all under lockdown and we can't do this kind of service of contract. And in this day, in this era, sending documents via emails has been a norm for the past few years. So we should actually address this. So to allow it to be legal, it's effective and legal, and it won't be challenged by anybody else later on. So the last one would be, this one is more applicable to the Crisis Interim Measures Act. Now, the reason why is because we wanted the Crisis Interim Measures Act to be an active response legislations. So in the act, it can have preparation of effective implementation of the act. So it preps ministries to have contingency plans in place and also review it periodically. So that in the event of crisis, we are not scrambling ourselves, we are on top of our own game. Malaysia is on top of its own game. And during the CIMA, consultation can be done with all relevant stakeholders, etc. Now, as a part of a conclusion, moving forward, please. Next slide, please. Yes. So any legislation relating to COVID is necessary to carry out the intended effect to reduce the socio-economic impact of COVID-19. Now, the government, as per what Rizal was saying, is that we have a portal that's already set up already. The due date for submission of recommendation and suggestion is tomorrow, Friday. So please go and include your suggestions. And what we can learn a lot from the past MCOs and COVID-19. And to bring it another step forward is that we should consider CIMA, actually. It's much like the Prevention and Control of Infectious Diseases Act. So at least at that point, at least when the crisis happened, we had that act, and our DG was on top of things, our Ministry of Health on top of this. From a health perspective, we were under control. So from a social economic perspective, CIMA was something that CIMA can address it as well. So it will cushion all the adverse impact on businesses during any crisis. So that's all from me. On to you, Rizal.
Thank you very much, David and you, Fern, for the presentation. Very concise. Well, both of you walked us through the real impacts of COVID-19 faced by the private sector. You also shared what other countries have done to reduce the impacts of COVID-19 from regulatory approach. You also offered options and scope of the legislations towards the end of presentation. You've raised a lot of interesting points today. So, ladies and gentlemen, thank you for bearing with us for the past 20 to 30 minutes. I can see from here that we have some questions from the participants. Well, I may not be able to read out all questions here as far as the time limit concerned. I'll just read a question or two or more for our speakers to respond if time permits. So I have 3 questions here from a participant, Mr. Si Xiantian, if I pronounce his or her name correctly. So the first question, do you expect the Act to delegate power to create regulations and rules under this legislation to the actual implementing agency, or will these remain centralized?
Mr. David?
Oh, thank you. Yeah, thanks. Very good question. I think it depends on the particular provision concerned, the particular area of law concerned as well, and the particular impact it is intended to achieve. Of course, delegation of power can be considered, but I would imagine that it will be the National Security Council that will then determine how and who is entitled to implement any of these measures brought about by the relevant laws.
Okay. Would you like to add anything, Ms. Yifan? Go ahead.
Yeah, I totally agree with what Mr. David said. I mean, if it's a CIMA, then we actually expect it to be subsidiary legislation to be issued out under the CIMA. The COVID-19 Act, I do not know how the BT or DSEU is going to do this, but perhaps it's better to have a COVID-19 Act in itself, and then that's how I think about it.
All right. Let's go to the next question. And this question concerns with the businesses trading across borders. So in respect of cross-border contracts or transactions, how do you expect differences between national COVID-19 legislation to pan out?
Well, much will depend on the choice of law clause in the contract itself. If the choice of law clause is Malaysian law, then the relevant applicable law would be the Malaysian law, right? However, the contract is subject to Singapore law, then we will make reference to what the Singapore position would be. So it all depends on the choice of law clauses contained in the contract itself.
I have an interesting observation is that the Singapore COVID-19 Temporary Measures Act is that it's only applicable to contracts that is for certain certain businesses, and it's already undertaken in Singapore. So it's very exclusive. So something that, whether we should actually extend it to cross-border contracts is, first of all, when it's extended to, one is a choice of law, but in terms of enforcement, let's say if it's another country, how would somebody going to enforce that our COVID Act in another country, because it may not be recognized. So there is a a difficulty in all those things. So perhaps the government may consider limiting the jurisdiction as well, for purposes of Malaysian contracts undertaken in Malaysia, and things like that.
As we are aware, in the trading across border, there are some international organizations that oversee the whole process of export and import procedures. For example, World Trade Organizations and some agencies on the United Nations. So should we respond or align this legislation to the international demands set by these international organizations?
Yes, of course. The temporary measures law, as we are introducing or proposing now, can also contain certain application on international contracts like that, those which are governed by other, as how you have described. Yeah, so in those forms of contract, then of course, yes, we will then uphold whatever international changes or international rules that have been implemented by those relevant bodies. So the Act itself can cater for such eventuality or such application of such contracts.
Mm-hmm.
Yes, I agree with Mr. David.
All right, sure. This is another question from a gentleman, Encik Muhammad Aizuddin Norazman. He recalls this. He recalled the past events, past economic crisis, for example, SARS and financial crisis. So why do SARS and financial crisis not require special legislation like this compared to COVID-19? Perhaps the impact is the same, but the magnitude is higher for COVID-19, or probably because of a lockdown. Should we actually amend the act causing the MCO?
The act we are proposing, which is either the COVID-19 Act by itself or CIMA, as we called it, is intended to achieve or confer power to the Malaysian government or the National Security Council to declare whether a particular crisis requires a lockdown, temporary or otherwise. So that power will be vested into the particular National Security Council itself to decide, to determine, given the gravity and the severity of the crisis itself. With regard to SARS, yes, it was a pandemic, but however, the impact is not as unprecedented as COVID-19. As I mentioned in my presentation, COVID-19 affected almost every country in this world. And like SARS, perhaps only particular countries in this region. With regards to financial crisis, of course, it is also akin to a crisis like this nature, but however, financial crisis will be more linked towards borrowings of businesses that were carried out, and because of the downturn or because of any economic adverse issues they had, it was pure financial crisis as opposed to this one, which is a combination of economic, social, and all sorts of effect that it has on everyone.
So different crises or problems happening in the country will require different solutions to be tackled by the government, I suppose.
Yes, you're absolutely right.
All right. Shall we move? Shall we move to the next question? All right. How does drafting a CIMA legislation comply with the good regulatory practices, the GRP? If I may
So
repeat,
can I rephrase? Yeah, please.
How does drafting this legislation as a CIMA legislation comply with GRP? Yeah.
Now the GRP is that it should be reducing regulatory burdens, you see, and it should promote and ensure that businesses will be more productive and in terms of its business. So what we see from CIMA is that it's not a it's not a regulatory burden, where it's because when crisis happened, and you don't have a legislation intact, and then the social economic impact is going haywire. At least CIMA is trying to address that issue. So it's trying to reduce all the burdens with the fundamentals there. So at least so that when a crisis happens, we are actually helping the businesses accordingly. So that is what CIMA is in terms of GRP.
I believe the private sector looks forward to the CIMA legislation being implemented very soon. Removing the regulatory burden borne by the businesses, by the private sector especially. Right. Given the current happening in our country, is it realistic to expect this legislation to be expeditiously passed?
CIMA.
Yeah, you're right.
Okay, one, I would actually think that it would not be expeditiously passed because one, if you're proceeding with COVID-19 Act, right? I think it's best that government enacts a COVID-19 Act, and then you see what's the implementation, what are the loopholes, what can be enhanced, and therefore then you do the CIMA so that you incorporate everything, your lessons learned into it. So it's more future-proof and foolproof in a way, and also they have to consult with a lot of public consultation as well, consult with a lot of public or the relevant industries as well for purposes of enacting the CIMA. So it will take some time. But COVID-19 Act should be the one to address immediately.
Would you like to add any, Mr. David, to you?
Yeah, I think the immediate need now is to have a COVID-19 law act to perhaps provide the force of law for certain announcements that were made or certain measures that were taken. Like, for example, whether the computation of time or statutory computation of time frame actually applies, which were not addressed. So I think there is an immediate need and urgent need for the COVID-19 law to be passed. But at the same breath, I think that the CIMA would be suitable for future use, and of course that it is entitled to extend to future events. Adequate and sufficient consultation and dialogue must be held with the relevant organizations, the relevant stakeholders and associations to ensure that it's a win-win for everyone.
All right, David, to continue with that, what do you foresee if the passing of the CIMA legislation is further delayed? What would happen to the private sector?
Well, I think, like we mentioned or suggested, perhaps in the interim period, the COVID-19 bill or act will address those challenges that the businesses are experiencing now. The CIMA will probably, when it comes into play, or if it comes into play, will then tackle situations in the future. So, yeah, that is how I would address it.
So it's not a mutual exclusive kind of approach. So you can have one COVID-19 Act and or the CIMA. So, but the CIMA, once the COVID-19 Act comes into force, the CIMA can come into force as well.
All right. During this critical time, while every government agency is working hard to help private sector to stay afloat, which do you think the government should prioritize, the temporary measure or the CIMA in this short term as an immediate measure to reduce the impacts of COVID-19?
I think in the immediate, you will require COVID-19 to address the challenges which are being faced by all businesses and individuals. Yeah, of course, like we mentioned earlier, the CIMA will take time, given this necessity to have deliberations and dialogues with all the interested parties.
I agree.
Okay, that's good. We would like to welcome more questions from the participants. You can do so by dropping your questions in the question tab at the right corner of your screen. Please, more questions. Okay, I believe, Mr. David, in the long term, future-proofing our country from any future crisis, not only the pandemic, but also global crisis, would be top priorities for the government. And this temporary measure, as in COVID-19 bill, will be overtaken by event when the CIMA is fully implemented in Malaysia. What do you think about it?
Yeah, I think that's where we are from, in the sense that in the immediate period or immediate time now, we will have the COVID-19 bill. But however, instead of just deciding to rely on the COVID-19 bill in the event a future crisis, touch wood, occurs, then at least we have the CIMA to cater for that particular eventuality. Having the CIMA, in our view, would actually prep everyone up. Like, for example, if there's a crisis declared, we will know that in all those housing development contracts, force majeure will come into play, for example. And if we have interpretation, if your contract doesn't have any force majeure clause, CIMA will ensure that your contracts are interpreted to include a force majeure clause. Also, with respect to how my colleague has pointed out, the definition of business days, with the definition being tied to banks being open and banks being in essential services, you have a situation whereby where the banks are open, the land officers are not, the stamp office is not. So those who are in the real estate practice will have this challenge of having to pay the stamp duty and to present the necessary instruments for registration when the time is actually running under the agreement, but you can't do anything because those agencies or relevant registries are not open. Yeah, so whether the COVID-19 Bill Act or whether it's CIMA, we were hoping that businesses of this nature can be addressed. The issues facing such businesses or such contracts can be addressed.
Okay, Ethan, anything you'd like to add?
I think CIMA it's a good legislation to consider for purposes of future-proofing Malaysia and from any crisis, and to ensure that Malaysia is on top of its game when a crisis happens in terms of a socio-economic perspective. And to me, I think it also gives investors a certain degree of confidence and certainty when a crisis happened. At least there is this act, these are the things that maybe these are the fundamentals that the government can consider, and at least the government is not the investors. From investors' point of view, we know that at least the government or the government of the day would know what to do with the CIMA, with whatever that's provided in the CIMA, rather than having nothing at all. You see, so it's a good, to me, CIMA is a good legislation to consider. That's the thing.
All right, thank you. I think I can take one last question, and this question concerns with the effect of CIMA or COVID-19 implementation. So, if the CIMA is passed, what would happen to all of the executive measures enacted prior to the Act? For example, the stimulus packages, the FAQs, the guidelines, and etc.
Well, what CIMA we intended to do is to cover the legal aspect or legal perspective of things like, for example, the interpretation of contracts, the interpretation of statutory time frame. With regards to stimulus packages, those will be independent and those will not be affected by CIMA in our view, because those will be announcement or stimulus packages announced by the government, depending on the severity of the pandemic or the grief that is suffered by all Malaysians at that point of time. So the CIMA is not intended to replace stimulus packages or provide any basis for making such stimulus packages. It will be independent. The CIMA, in our view, is basically to address the nitty-gritty of the contract, for example, the interpretation of certain clauses, for example, or the provision of time frames, as pointed out repeatedly. Yeah.
I agree. Totally agree with Mr. David.
All right, sure. All right. Thanks, David. Thanks, Ethan, for responding to the questions and the presentation too. Wonderful. We are very grateful to have both of you in today's webinar. Would you like to say a few words before I conclude our session? David.
Again, I want to thank MPC for having us on board to provide us this opportunity to air and share. Just want to say that we're all in this together, and together we will be able to combat this.
All right.
Yes. Yes, thank you MPC for the opportunities, and we hope that COVID bill is up and running as soon as possible. And if there's any feedback to the COVID bill, please do submit your recommendation and suggestions.
So thank you, David. Thank you, David and
you.
Fern. Ladies and gentlemen,
Thank you very much.
all right. David and Fern are also on LinkedIn too. If you wish to connect, search for Zul Rafique Partners. They're happy to connect with you. I would like to thank you all so much for staying with us till the end. As today's webinar is recorded, the recording link will be shared with the participants as soon as it is ready. Also, don't forget to visit Unified Public Consultation. Drop your comments and suggestions to the COVID-19 bill. Today is the last day to share your feedback. Your feedback is valuable to the government. The links can be found at MPC's Facebook page, Twitter, and Instagram, or you may directly visit upc.mpc.gov.my. Hashtag Our Voice Matter. For those interested in getting advisory services in quality regulations, get in touch with Virtual Advisory Clinic by RIA. Your specialists are looking forward to getting in touch with you soon. And last but certainly not least, thank you very much to MPC for hosting today's webinar. Learn more about upcoming webinars hosted by MPC at mpc.gov.my. All right, folks, stay home, stay safe, stay healthy, stay productive. Avoid 3C, practice 3W. I am Rizal Muhammad. Thank you for listening.